Welcome to this dialogue from our Migration and Mobilities Bristol Center. We are a research center on migration issues, and we have a particular section of our center devoted to Latin America, where we have blogs and analysis, not only in English, but also in Spanish and in Portuguese. Today, those two sections of our center, the General Center of Migration and Mobilities Bristol and our section from Latin America, are organizing this panel, this discussion, where we're going to be talking about the UN Migrant Workers Convention. Why now? Well, we're talking about the convention now because on the 18th of December last year, the convention celebrated its 30th anniversary. So we thought it was an important moment to assess the successes of the convention, but also the challenges that the convention faces, and to explore some possibilities of future developments. I am Diego Acosta, and I am a professor of European and Migration Law here at the University of Bristol, and also the International Strategic Lead for our Migration and Mobilities Center. Together, today we are joined, and I'm very pleased actually to welcome Dr. Pablo Ceriani. Pablo is the former vice chair of the Committee on the Rights of Migrant Workers, and he's currently the director of the Specialization of Migration, Asylum and Human Rights at the University of Lanús in Buenos Aires in Argentina, and he's also a consultant for different international organizations. We are also joined by Alvaro Botero, who is currently member and vice chair of the Committee on the Rights of Migrant Workers, and he is also coordinator of the Organization of American States Unit on Refugees and Forced Displacement. So we're really pleased to welcome them, because obviously they are the type of experts that we need to have this discussion about the convention in its 30th anniversary, but also about the functioning and the role that the Committee on Migrant Workers plays in overseeing the implementation of the convention in the 56 states which are party to the convention, and also perhaps in encouraging other states to also join this important convention. So we are going to I'm going to ask the two speakers some questions through which we are going to introduce the role of the convention, the role of the committee, but also some of the, as I mentioned, successes, but also challenges facing this convention. We are going to speak for around 30 minutes, and then we're going to open the floor for discussion, for questions and for comments. You can use the Q&A that you have at the bottom of the page, and later, depending on how we are doing with time, we might give you the floor to use your microphone, or we might simply read your questions. So I'm going to start. And perhaps the first question that I would like to ask both Pablo and Alvaro is whether they could briefly explain to the audience what is it that the convention does, and also perhaps explain briefly what is the role of the Committee on Migrant Workers. I don't know who would like to start. Perhaps I'll give the floor to Pablo to start.
Thanks, Diego, and thank you very much for inviting me or inviting us to have this timely discussion. I'm very pleased to be here. Okay, and I will just add, some reflections on this first question, but I guess that Alvaro, a current member of the committee, will explain more on the convention and how it was adopted and its content. But let me say, first of all, because I think it's a critical matter, that there is some kind of idea that the convention has a very narrow approach and it's only limited to migrants while they are workers and related with only issues on work and labor. And of course, that is part of the content, but when you see the convention, when you read the convention, and in particular when you read what the committee has been doing in its role of and duty of the interpretation of the convention and the way that state parties are implementing the convention, it's just not about workers, it's migrants in general. And I would say, if you read carefully the decisions, each of the recommendations that the committee did to member states of the convention, to the state parties, to some extent, also including asylum seekers and refugees' rights. So this is mainly through the role of the committee, and in the applying principles of progressiveness of human rights, and this principle of that treaties has been applied as living instruments in order to cope with the challenges in terms of human rights protection in current times. So this is like a very wide scope in practice, and also not only about the content, classic content of rights. I mean, every migrant has this right, and right to life, and right to healthcare and education, and so on. But there is also a large convention. It has an entire section on cooperation, on regional cooperation, regional policies, migration regional policies, bilateral cooperation. So it goes far beyond what a classic human rights treaty has in terms of contact. And then, thinking on the role of the committee, I think that the periodic review that the committee does in terms of what each state party is doing in terms of implementing the convention is a unique opportunity for a comprehensive assessment on migration and other public policies that impact migrants and refugees' rights in the state party. So, of course, the Committee on the Rights of the Child addresses children's rights in the context of migration. CEDAW addresses women's rights in the context of migration, and so on, so on, so on. So it's a focused approach, which is critical. But then this committee and this convention allows all stakeholders in the state party to have this kind of comprehensive discussion. Every single piece of public policies that impact migrants and refugees' rights can be addressed and discussed when the periodic review is done every 5 years. So I think this is critical. And just for giving you some examples, if you read, I don't know, the recommendations of the committee to Mexico and Ecuador in 2017, Argentina 2019, Turkey 2016, you will find there like a very, very wide range of topics, human rights topics in terms of migration policies. So just an example of that could, in a way, clarify some myths on the convention and what the committee is doing.
Thank you. Alvaro, would you like to?
Yeah, well, first of all, thank you, Diego, and Migration Mobility's Bristol, at the University of Bristol for this important event. As a member of the committee, I'm very excited to be able to talk about the good practices and the challenges that the committee has faced in its 30th anniversary since the adoption of the convention. So basically, in complete agreement with all of what Pablo said, I would just add that this is the most specific human rights instrument at the universal level or at the UN system that deals with the protection of migrants. And if you see the provisions of the convention and the broad definition of migrant workers and members of their family, of course, that is clear that this convention protects all kinds of persons that are in the context of international migration, and not doing that very negative categorization of, okay, if this person is looking or searching for international protection, therefore is not covered by the convention. No, like a progressive interpretation of the provisions of the convention, and also considering, as Pablo said, the convention as a living instrument has led to the committee to protect all those persons in the context of human mobility. Another aspect that I should say, yeah, to conclude with that, this is the most specific and important universal instrument in terms of the protection of migrants, comparing it with other human rights instruments at the UN level. But something that is important to take into consideration, and I'm pretty sure is something that many of the people in the audience face when they are working to promote and protect the rights of migrants, is that negotiations for the adoption of this convention show the political sensitivities that existed at the time when when the states decided to promote the adoption of this convention, and how difficult was at the end of the day to accomplish the convention. Basically, the process started in 1972 by some discussions at ECOSOC, and it took until 1990 to finally have a convention adopted. So this is basically a lapse of kind of 20 years to have a convention adopted. The other important point, and it's related to the first issue that I mentioned at the beginning, it's migration as a very complex process that entails some situations that happens in the countries of origin, situations that happens in transit, in destination countries, and now increasingly in countries where migrants are returned. That led to this convention to be the longest human rights instrument compared with other human rights instruments. The convention has 93 articles and is divided in 9 sections. And that also shows the sensitivities that North countries compare with countries from the global South had when dealing to this issue, and especially when deciding what kind of human rights, which should be granted to all human beings, should be conferred to migrants in an irregular situation, where we very often see the interlink between persons that are in that situation, but also persons that are in situations of poverty or vulnerability. And to conclude with that, I think that it is important also to deconstruct many of the myths that are around migration, but also that affects the convention and the work of the committee, that the convention does not create new rights. If you see the rights that are the convention are basically a specific application of other rights that are protected in human rights instruments. And the other point to conclude with the process of the drafting of the convention is that it also was the longest drafting process and the longest process for a convention to enter into force. The convention was adopted in 1990, and it took now another 13 years to have the states that were required for the convention to enter into force. In terms of the committee, basically the committee follows the same rules that other committees at the UN. There are 14 members that work in a personal capacity. We do not represent the states that nominate the members of the committee. There is a huge challenge that you can see during the history of the composition of the members of the committee, and is the poor representation of women as members of the committee. At the moment, for example, there are just 2 women as members of the committee, and basically that has been the situation for probably the last 4 years, and it's in clear contradiction with the feminization of migration. And it's something that is important for state parties, but also for all other stakeholders, to promote that there's more participation of the committee as members of the committee of women. I think I'll leave it here because Pablo already covered some of the issues about the main mechanisms that are available for the committee, like state parties reviews, but we also do general comments that helps to expand or to clarify the interpretation of the provisions of the committee. And in recent years, the committee has been exploring new ways to support the states in the implementation of the convention at the local level. Thank you.
Thank you, Alvaro. Following on one of the elements actually that you were mentioning, that it took 13 years for the convention to enter into force, and it only entered into force in 2003. One of the main criticisms to the convention has been its low ratification. So there are 56 state parties to the convention, which, you know, if we compare it with other human rights instruments, like the ones you guys have already mentioned, it is extremely low in comparative perspective. So I have two questions here. First of all, why do you guys think that it is so difficult to convince states to ratify this particular convention? And at the same time, which are the actors, in your opinion, that facilitate at domestic or international level that states actually end up ratifying the convention? Is it, does it depend on the role of civil society at domestic level? Does the Committee on the Rights of Migrant Workers play any role in enhancing the ratification of the convention? I would like to explore those two dynamics, right? First of all, why the ratification is still quite low, 56 state parties, and then at the same time see what are the mechanisms or the actors that play an important role in improving that ratification.
Pablo or me?
Okay, just few comments on that, and I think it's an important question. First of all, I would say, I mean, one of the reasons they usually give for not ratifying the convention is that it's the convention only ratified by sending countries. This is not true. Some countries have always been receiving countries and ratified the convention, and many others have increasingly become, as Alvaro just said, I mean, countries not only of destination, of origin, transit, destination, return. Some of the state parties are dealing with a major human mobility crisis at wide level. No? I mean, think on Morocco, on Turkey, Colombia, Mexico, Ecuador, Peru, etc. So, and those states have the convention and one of the legal tools for coping with those challenges. No? And when you read the preamble of the convention, I mean, the need for every state at the General Assembly 30 years ago said that there is a need for protecting migrants' rights. The migrants live in vulnerable circumstances. There's a need for an harmonization of what is called the attitude of states through the acceptance of basic principles concerning the treatment of migrants. What happened since then? I mean, those needs are still there, are even worse. So what the issue is political. No? There is a political excuses for not ratifying the convention, and this is linked with the narrative or the restrictive policies that have been implemented in the 90s or even earlier in different countries. That it has been developed and reinforced every narrative that describes migration as a problem, as a threat, as a menace. It has become a tool for political purposes. Migrants have been used as scapegoats of different problems that societies are facing, and that led to reinforcing the restriction of rights, such as the right to liberty, using detention policies. Another arguments that those rights are already covered in other treaties and in national policies. Some states have been saying that. So that argument could have been used for not ratifying another treaty like CEDAW or Convention on the Rights of People with Disability. But even though they ratified, no, because it's also a matter of commitment with the international community. Another reason, I mean, they say that they provide many rights to undocumented migrants. But then when you read the jurisprudence of the CRC or CEDAW or the Committee on Economic, Social and Cultural Rights, or even regional Court of Human Rights, like the Inter-American Court, it's the same standards. So it's not that the convention adds more rights or adds another standards. They are the same. So it's just a political issue. In terms of how to address that, how to change that, of course, civil society can play a key role. They have been doing that since 1990. Those states that ratified the convention, in particular, those that did that in the last 15 years, in many cases, you can see civil society, international organization, and also the committee, but mainly civil society, international organization playing a critical role, not only for ratifying the convention, but also in pushing for some policy change, policy shift in national migration policies and ensuring to some extent with contradiction, with challenges, a rights-based approach to migration policy. So I think there are some key actors there that have to keep on pushing in partnership with the committee and another international actors for ratifying the convention.
Okay, perhaps let me ask Alvaro, following up on that. We obviously now have the Global Compact on Migration that was endorsed by 164 countries in Marrakesh, and then 152 countries at the level of the UN General Assembly. How do you see, Alvaro, the relationship between the convention and the Global Compact, especially in your role now as Vice Chair of the Committee on Migrant Workers?
Yeah, that is a very critical question in this discussion, because something that is important to that we do not forget, and that we keep that message clear within the international community and with the states that still haven't ratified the Convention on Migrant Workers, is that the convention is a binding instrument. The convention is as I said before, the most important instrument in recognizing that migrant has human rights, and how we as an international community, and as societies, consider migrants also as human beings and not as a separated category of being. No, if we understand this basic premise of human rights as the rights that are guaranteed to all human beings, then we have to understand that have to have some practical application for migrants. So in that sense, I think the discussion and all the process that led to the Global Compact on migration, it was very important in the sense of renewing the discussion and the need to have some basic understandings and commitments for migrants, and to regulate and not keep that negative approach of preventing and deterring migration, which it has been a natural phenomenon during the history of humankind. But so, besides recognizing the importance that the process of the Global Compact gives to start or to renew the discussion on migrants, which is a discussion that has never disappeared, the convention still remains as the main human rights instrument for migrants. And I think that there are many interlinks between the convention and the Global Compact. I hope that if there is a good faith on states to commit and to comply with the commitments that they assumed when adopted the Global Compact, this eventually will also lead them to ratify the convention. Something that has had some discussion inside the committee during the last 2 years, it's also seen the possibilities of eventually drafting a general comment on the interactions between the convention and the Global Compact. But yeah, let's just not forget that the Global Compact is not a binding instrument in terms of human rights protections. If you see the references to human rights instruments and conventions, it's very scarce in the text of the Global Compact. You just can see one reference in a footnote. I think it's the first footnote that make reference to human rights instruments and the convention, which is kind of shocking in terms of the prevailing conception or approach that many states still have to the convention, and to, in a broader sense, to recognizing human rights to migrants, irrespectively of their status. No matter these challenges, I think we need to see this as an opportunity and to try to find the interactions. And as Pablo said, yeah, to keep working on the ratification of the convention. And I think the news of Togo recently ratifying the convention, it's a signal of hope and a signal that we need to keep.
Okay, and you know, following, we have discussed some of the challenges of the convention, but let's perhaps move into some of the successes of the convention. In your experience, can you identify perhaps some good stories, good examples of things that have changed, policies that have changed, or even legislation that has been amended or adopted in view of comments that the Committee on the Rights of Migrant Workers has provided to a particular country? Can you perhaps share with us some good stories and good examples of good practices from state parties that have followed comments from the committee, or simply that have followed the adoption, the ratification of the convention itself. Perhaps, Pablo, if you would like to start. And
yes, I mean, there are many examples. It's not always easy to draw some kind of direct line in terms of cause and effect in every policy change and decision that state parties have taken since they ratified the convention. But let me first say that also the effects and the relevance are can be seen in another kind of initiatives, such as initiatives in partnership with other human rights protection bodies, like the Joint General Comment of the Committee on the Rights of the Child with the Committee on Migrant Workers, that evidence this intersectionality, interdependence of rights. And now the CRC is implementing that Joint General Comment to each state party, which is every UN member state except the US of the world. So there are another effects and positive outcomes of the role of the committee and the implementation of the convention. But when you see some policy changes, for instance, the human mobility law in Ecuador that was waited for almost 10 years since the constitutional change in 2008, it's not necessarily a coincidence that it was finally adopted 6 months before that Ecuador had to submit it, the periodic report before the committee. Also, the change of migration law, the new migration law in Mexico in 2011, children's rights law in Mexico 2014, and also recent changes in terms of removing children for detention for immigration purposes in Mexico. There are some of the and some policy changes in Argentina. So you could find like a long list of changes. Of course, the convention and the committee's role have not been the single cause that led to some policy shift. There are many factors that gathered to some point in time and place to get to that policy change. And you could say the same thing to every single human rights reform on children and women's rights and also. So there are a number of factors of causes that led to that change, but you can easily identify this process in the case of the Migrant Worker Convention and the role of the Migrant Workers Committee.
Excellent. And perhaps moving now to Alvaro, since you are Colombian, and obviously everybody is now talking about Colombia and the new temporal complementary status to Venezuelan migrants that has been announced. We still don't have the final decree regulating the precise details of what that is going to entail, but it is expected that around 2.5 million Venezuelans might benefit from this 10 years residence permit. And if we read the decree in the preamble, there are several mentions of the Convention on the Rights of Migrant Workers. Has the committee played any role, or can you see any relationship between the adoption of this extremely important instrument, not only for Colombia, but for the region, Latin America, and I would say for the whole world, because it is a very interesting instrument in its provisions. Can you see any, has the committee played any role, and perhaps even, you know, in your capacity, not only as vice chair of the committee, but also as a Colombian citizen?
Thank you, Diego. Yeah, actually, I'll take that question in my individual capacity and not as a member of the committee, because we should refrain to address issues related to our country. But as this is an academic event, I think yeah, everyone can have an opinion about this. But definitely the decision adopted by the government of Colombia, it is probably one of the most important decisions that we have seen in migration policies in, for sure, the last 20 years or so. As you said, this measure adopted by Colombia can open an avenue for regularization and protection for 10 years for almost 2 million of migrants that are currently in Colombia. Actually, the most recent estimates are that there are 1.8 million of Venezuelan migrants that have arrived to Colombia since 2015. This is not a minor thing, and I think this should lead us to rethink many of the myths and misconceptions that are around migration and about the capacities of states to receive migrants, about the capacities of states to develop policies for the integration of those persons. Of course, in Colombia, there are many challenges in the effective integration of these people. But what I think it is important is that it is not just a matter of resources, it's more a matter of political will in doing things in the right way. Of course, Colombia will have to secure resources, and it will be fundamental to see what is the role of the international community supporting a country that also have faced an internal armed conflict for many years. But yeah. But going back to your question, I think the references that you made highlight the importance of the convention, in the sense that the Colombian government took into consideration the provisions of the convention when designing this important decree. Another thing that I think it's very important to take into account is that Colombia had its state review just 2 years ago. It is difficult to count 2020. But yeah, with the state party review, there was an excellent opportunity to see all the important measures that Colombia was taking at that time, and also an opportunity for the committee to push the avenues with Colombia to open regular channels for the migrants that were in the country, and especially those in irregular situations. And the other thing that I think it might have played an important role in that is that the committee also adopted a joint statement to address the mass migration of Venezuelan migrants and refugees in September 2018. That is one of those interesting mechanisms that the committee has started to use more often in recent years. And the importance about this joint statement that was adopted also by the Committee on the Rights of the Child, the Special Rapporteur on Migrants, OECHR, and the Inter-American Commission of Human Rights, is that one of the measures that the committee and the other bodies recommended to Colombia was, to protect those that should have international protection or should be protected as refugees, to guarantee that, but also to open other avenues as temporary protection or complementary protection. So we can see, and clearly the temporary protection status for Venezuelan migrant is an implementation of this. So I think these statements made by international bodies as the committee played a very important role to frame the discussion and to give guidance on how international bodies consider that these issues can be addressed at the national level. Of course, just to finalize this point, the effect utile or the impact of the convention depends on how much life do we give to the convention and to the committee. To what point this is a living instrument that might have an impact, it's not just a responsibility of the committee. Of course, it's our main responsibility, but much of that also depends on the role of the civil society organization, on the role of litigants, other international bodies in using the convention, and also pushing the committee to fill the gaps in terms of the protection of migrants. To the point that we do that, we will see how much impact the convention can have. But yeah, as Pablo mentioned, there are many significant examples in the short term that the committee has been in existence, which is kind of a short term comparing with other committees, that give us hope in terms of the utility of the committee and the convention.
Okay, excellent. I'm going to ask you a final question. I just like to remind the participants that you can, and some of you are already writing your questions in the Q&A section, so I'll give I'll ask those questions that you're writing in a second. But perhaps my last question before we move into the questions from the audience is, what will be the main problems that you can identify? We have talked about the successes in some countries, but what are the main problems that you can identify in the 56 state parties? Is there any particular area of concern that you can see across a number of countries in your reports, or that you can see as being a recurrent issue in the various state parties when they are submitting their reports?
Well, of course, they have been dealing with some of the same challenges that those states that haven't ratified the convention. I mean, political pressure, setbacks, a narrative with xenophobia, racism, and so on and so on. And in many cases, those state parties are also dealing with huge crises or human rights crisis for the whole population. It's not only about migrants in vulnerable circumstances. It's many people, like people in Latin American countries, are also dealing with human rights issues. So that also can be used for discussing with those state parties in the global north. I mean, how can you cannot include this tool? I mean, when those states and those society with more and more challenges have done so. But one of the main challenges or repeated challenges that the narrow institutional framework that many states adopt in terms of migration policy, the key role of Ministry of Interior, Ministry of Security. So that contributes to some of the key or the common challenges in terms of securitization, the use of detention policies, or human rights violations at borders, or a narrow approach in terms of restricting social rights of migrants, or restricting or political rights. This kind of issue are repeated, and in this, and also there is some kind of misunderstanding in some cases when you read the reports of some state parties. I think that they may not have followed this kind of progressive interpretation of the convention, this idea of the convention as a living instrument. So they sometimes they keep on the literal wording of the convention 30 years ago, instead of this kind of wide, a more living and effective approach to the wording of the convention in order to become a useful tool. So these are some of the challenges, and then I mean the same challenges than other regions, the regions with countries that mostly didn't ratify the convention, in terms of children's rights violations, women's rights violations, and so on. And an additional challenge, I would say, is that in a way, there is a need for more interaction and action and strategies and use of the committee by civil society. It's not that they don't do that, but they face with so many challenges and urgent pressing needs at national level. So maybe using international mechanism may not be seen as a priority. And of course, it's understandable, but in addition, processes of the Global Compact also moved civil society to those kind of strategies when it comes to use international processes. And so instead of using this normative framework, so I think, of course, the committee has to do more and more and more in order to invite civil society, national human rights institutions, and international organizations to use this committee, because in a way the committee can be a sort of sounding board for discussing current challenges, and as in the case of Colombia, as Alvaro has just explained.